All right, thank you for joining all. Again, my name is Preston Bucati. I'm a GRC consultant with IT Governance USA, and today we're here to talk about security and the law, specifically how the model rules of professional conduct, which govern the rules and the practice of attorneys and legal services here in the United States, and how those are increasingly being interpreted to apply to data privacy, cybersecurity, and other technology requirements applicable to legal practice and law firms, which traditionally is an industry that's somewhat behind the times when it comes to technology. So hoping today to dig into some of that in a bit more detail. Again, thank you for those of you that joined. We're going to go ahead and get started here. The one thing I will say as a bit of housekeeping before we do move forward, you should be able to submit questions via the GoToWebinar feature. So if you do have questions over the course of this webinar, or of course at the end of the webinar when we have some time for questions, feel free to submit those through the GoToWebinar function. Please just keep in mind that it takes about 60 seconds or so for those questions to funnel through the technology and get over to me. So I will build that time in with each slide just to allow some time for questions to come through. But again, keep in mind if you ask a question, it may perhaps take a second or two before it comes onto my screen and I can reply to that. You're also always welcome to reach out to me or anyone else from IT Governance at any time after this webinar. If there are dedicated questions you wish to discuss offline, no worries there. We'll send out contact information and you're more than welcome to get a hold of us. So with that, let's get started today discussing cybersecurity and the law, how cybersecurity and IT compliance apply to legal practice. Now, a bit of background on us and who we are and why we're qualified to make these statements. Again, my name is Preston Bucati. I'm actually an attorney here in the United States. I've got my bar license in several states here in the Midwest, and I work as a GRC consultant for IT governance. It's a one-stop shop for governance, risk, and compliance, especially in the field of IT, IS, and cybersecurity. So we have a variety of products and services available to help your organization get up to speed on cybersecurity requirements, whether that's something more light in terms of a document toolkit or perhaps just a pocket guide to educate you on some of the topics you see there on your screen, requirements like PCI or ISO or NIST and others. Variety of light sort of offerings all the way up through to employee training that we're welcome to provide to you in a package or come to your site, all the way up to full-blown consultancy services where we'll actually work to help you achieve accredited certification under some of these risk management frameworks. So you can see there on the right, ISO 9001, we also specialize in ISO 27001. So there's a variety of consultancy services available to help you with audit functionality or actually full-blown certification. Again, also a variety of services available as they regard individual consultancy on US or European or other international data privacy and cybersecurity laws. So there's a lot of options available. If you're interested in reaching out, go ahead and give us a shout after the webinar. And as a special offering for those of you that have joined us today, we're giving 15% off any ISO related products between now and March 31st. So if you're interested in achieving ISO accreditation, if you're looking to get some sort of internal audit done before your formal surveillance audit, or perhaps you just need some guidance on what the heck ISO is and why it's valuable to your organization, reach out and like I said, there's a special discount going on this time of year for those of you jumping into these topics as we head into Q1 and Q2 of 2019, trying to prepare ourselves for what may eventually come down the pipeline from the federal government around data privacy and cybersecurity, although the cynic in me is not too optimistic there, but we shall see. Now, brief agenda here, and I'm hoping that this resonates with those of you from the legal audience. We're going to briefly go over what the issue is and then talk about the rules and how those rules, specifically the model rules of professional conduct, how they actually apply to the practice of legal services and attorneys here in the United States, what those rules actually mean in terms of processes and people, and then of course a brief conclusion to wrap it all up. So using that IRAC formula or that CRAC formula that we all learned years ago, let's dive in first with, and what is the issue? Now, the issue for those of you that haven't been paying attention to the news for the past 3 years is that cyber breaches are happening at an astounding rate for two reasons. Number one, Primarily, technology has facilitated a vast increase in the collection and storage and manipulation of personal data. Companies around the globe are realizing the financial value or the business value of collecting this information and using it. On the flip side, you now have all of these cyber criminals that are saying, hey, companies are collecting this in mass. We've got lakes of personal information scattered across the globe, and we can pick and poke and steal from those lakes and get data we need to start doing things like identity theft, spear phishing campaigns, or other nefarious activities to try and monetize that data and eventually steal something from someone. So today's discussion, like I said, first we're going to focus on the issue, why is cybersecurity management increasingly important? Well, a lot of this data that I'm about to show you today is coming from 2018 industry surveys on the state of cybersecurity and incident response management across industries. So much of this data is actually going to be subdivided by industries, but some of it's going to be high level like you see here. Most of the time, when hackers are accessing systems, the ultimate goal is financial, right? You can see there that yellow line. There are certain people, and I'm sure you can maybe think of certain countries that are engaging in cyber espionage, perhaps to steal intellectual property, perhaps to just understand what their competitors are doing. Below that, though, is the much more low-level sort of trolling activities that we maybe are all familiar with across the internet, right? Maybe you've got some kids playing around with technology just to see what they can break. Maybe somebody is looking to get back in an old boyfriend or girlfriend. But most of the time, when we talk about cyber incidents and breaches at corporate scale, the real true motive is financial. At the end of the day, these are criminals doing the same thing criminals have done for thousands of years, right? Now, we can see here the number of breaches and incidents split up by sector. Now, a key point to understand for those of you that are primarily rooted in legal practice and maybe aren't really familiar with the terminology of information technology, key thing to consider here, there is a difference between an information security incident and a full-blown breach, right? And surely anybody involved in the legal practice can understand how there's a bit of gray area in how we define issues. An incident is something that happens, it perhaps compromises information security, it perhaps indicates that there is an issue. Obviously, though, a breach is a full-blown, we need to be on CNN, we've got to call our head of PR, and we got to get people working on this, right? So an incident could be some reporting from employees that malware has breached a system or something's not working, whereas a breach is an actual verified, hey, this has escalated beyond an incident to an actual issue. You can see here the number of breaches and incidents broken down by sector, and there are a couple interesting things to take away here. Number one, of course, the biggest industry that is subject to cyber incidents is healthcare. So if you are involved in healthcare in terms of dealing with healthcare issues with your clients, or perhaps you support healthcare clients like a hospital network, something to keep an eye on. Primarily, and this is mostly anecdotal experience based on our work at ITG, a lot of healthcare companies are subject to cyber incidents for twofold reasons. Number one, the value of their information is incredibly important. Think about it. When you go to the doctor, you're not only giving your name and address and contact details, you're often also giving your social security number, insurance information, financial information. There is a lot of valuable data wrapped up in an average healthcare or doctor visit. On the flip side, most of those people, and I don't mean to be disparaging, but most of those people don't accelerate in information technology, right? Technology companies, the Facebooks and Googles of the world, they have armies of systems engineers that they've hired from the best universities from around the world. And not that healthcare industries don't do that as well, but typically healthcare is more focused on providing health, right? Doctors, nurses, medicine, medical devices. A lot of systems and legacy architecture can be built up over time at a healthcare network, and it's not necessarily going to be as streamlined as it would be, say, at an app company based in Silicon Valley. Now, naturally, that, of course, is always going to be a big, big sector that's going to be subject to breaches and incidents as well. You can see there information technology, kind of a big one. And that's the same reason that I just talked about, right? Companies like Google and Facebook are vacuuming up as much data as they can find on the internet. And so they just present a high value target to criminals because there's a huge repository of information that's available there. On down from that list, you can see some other industries, right? Financial, obviously, perhaps a big one. Can we steal some financial information, mergers and acquisitions, details, trade secrets, etc. Accommodation, perhaps you can pretend you're a celebrity or engage in blackmail with a celebrity if you find out personal details of where people are going and what they're doing. Obviously, all of these typically include payment information as well. But you'll see there towards the bottom, professional services, typically where the law or legal services industry lies. Not a huge vector of breaches and incidents right now, but I'd like to challenge you with that, with some couple ideas. So before we get into that further, I want you to just understand the evolving nature of cyber attacks, again, at a high level. So this slide in particular is focusing on the top 5 most common cyber attacks, and you can see that in the graph on the right. But I'll give you some additional detail. The amount of breaches by pattern, about 20% or around a fifth of all breaches are coming through web applications. Again, for those of you that are maybe a bit technically challenged, web applications are something that you're going to find through a browser. So it may be something like an extension to Microsoft Chrome, a tool you use. If your company has moved entirely to a cloud environment, you may be utilizing a lot of web-based applications. That presents a lot of vectors for attack into your systems, because essentially you've offloaded everything off of your physical into the cloud, and now that can all be breached and attacked. Now, an interesting thing to note there, you'll see 18% of all breaches, again, fairly close to about a fifth of all breaches, are caused by miscellaneous errors. Do you know what that means? That means that an employee of yours pushed the wrong button, typed the wrong thing, called the wrong phone number, emailed the wrong person. It's basically an everyday mistake. That type of stuff that happens to us every day where we're tired, we're busy, we didn't get coffee at the right time of day. All of a sudden, we fire out information to the wrong party. This is key here to understand, guys. In Europe and increasingly in the United States, a quote-unquote data breach is not just a, hey, someone broke into my system. It's the inadvertent or unauthorized disclosure of information. So if your secretary or your paralegal emails a client file to the wrong person, and this wrong person can access personal information in that client file, that is technically a data breach. Technically, you are now responsible for reporting that to 50 different state attorney generals, on top of European regulators if European citizens are involved, not to mention Russia, China, India, Brazil, and other countries. So something to key and really focus on there. We'll come back to that topic, but a damn near fifth of all breaches are caused by internal miscellaneous errors. Now you'll see there on the flip side, a lot of breaches, like we saw in previous slides, are really financially motivated. So when they are coming from external parties, most of the time that's financially motivated crime. When it's coming through internal parties, most of the time that's inadvertent mistake. But we'll talk more here in a second. You'll see there on that second bullet, threats. 73% or almost 3/4 of all attacks are coming from external parties, whereas 28% are actually coming from your own employees. So we'll dive into that here in a second. But one key thing to consider is that that matrix changes a little bit when we focus specifically on professional services as an industry. So you'll see there, again, it's sort of a 70-30% split. Most of the time, you're being attacked from external parties that are looking for financial remuneration, some sort of crime to commit where they can make money and profit. But 30 to 28% of the time, your own employees are going to cause a breach. Now, some key thing to consider, when your own employees cause a breach, that could be inadvertent mistake, miscellaneous error like we just talked about. It could also be actual motivated intent. You may have an aggrieved employee that's looking to steal data before he or she goes on to the next employer. You may have an aggrieved employee that's just looking to take you down in the news. And so, you know, they're a whistleblower, or they report you. There's a variety of activities. Maybe they're contacted by an outside party and they're trying to make a little money and steal things from you by virtue of their access. Whatever the case may be, it's just important to understand that while most of the time your attacks are coming from external parties, a good portion are also coming internally. Now you'll see there that other bullet point, 50% of those external attacks are actually being orchestrated by organized crime networks. These are not kids sitting around playing on computers. These are not men in ponytails that are just playing to see what they can access on your server. These are sophisticated criminal networks that are sometimes state-sponsored, looking to see what they can get. And those range across the globe, but again, just something to consider there. We're not just talking about random crime. I'm not worried about some guy hacking into my server. I'm worried about an organized criminal network that is dedicating resources, people, teams of people, millions of dollars, lots of technology thrown at them in order to see what they can steal from your networks. Now, ransomware, for those of you that don't know, is a particular type of malware, essentially a virus that gets attached to your system or your network or your device, and it locks you out of that ecosystem until you pay a ransom, right? It was very popular a couple of years ago. It seems to be falling by the wayside as a vector of attack for these criminals, but right now that represents about 40% of all malware. So very interesting, and we can talk about this in more detail, but ransomware, one of the quickest and cleanest and easiest ways to prevent yourself from being a victim of ransomware is simply copying your information, right? If somebody locks you out of your laptop, but you have all the files saved on a cloud server, I don't care if you lock the laptop, I'll just erase all the data, spin up a new operating system and download my files again. No harm, no foul. So again, as we understand the nature of these attacks and the vectors that criminals are using, you can start to prevent and protect yourself with a variety of either technological or process-oriented controls, which we'll talk about more on that application section of today's presentation. Now you'll see here also under ransomware, 50% of 50% of these attacks are coming from hacking, real brute force hacking attempts, whereas 21% are actually coming from social engineering. Social engineering, for those of you who don't know, it's essentially pretending to be someone you're not, right? So perhaps a criminal pretends to be one of your vendors. Hey, we didn't receive that check last week. Do you mind sending it to this account in China? Maybe it's somebody who pretends to be an employee or a client. Hey, I was here last week and I was here to meet Bill and he said I could just come into his office. Is that okay? Social engineering tries to take advantage of people's, number one, their gullibility, but also other human emotions, things like a desire to be liked, a desire to do a good job. Most of us in our day-to-day jobs, we just want to do a good job, right? And so if I get an email that looks like it comes from my CEO and he says, hey, Preston, you owe me $10,000. Can you send it to this account and I'll pay you in a week? It's an email from the CEO, right? I may just fire it out. Well, that's where, again, having some internal training or internal controls around your own employees can help protect your overall liability in terms of data breaches and data incidents. So something to keep in mind there, again, most of the time, financially motivated criminals trying brute force attacks, but you may also be subject to social engineering attacks that take advantage of people's relative unawareness, and your own employees that are maybe just taking advantage of your trust because they happen to already exist on your network. Now, on that point, to elaborate further, here's the real scary part, guys. When you have a social engineering type of attack, a lot of times that's coming through phishing emails, right? An email that pretends to spoof someone's personality, someone's identity, and take advantage of your employees. There have been studies done over the years, and it seems to be that no matter what you do, somebody is going to click on one of those phishing emails. They're going to click on a link. They're going to click on an attachment. They're going to reply. 4% of all people will click on any phishing email no matter what you can do. Now, statistically, that's a very low number, but that is a risk you need to consider, that even if you implement technological controls and employee awareness training, you're constantly going to be fighting that battle against social engineering and phishing emails. What is even more scary is those data points right under that, right? 87% of those clicks on a phishing email take minutes or less. So if some criminal sends a phishing email, 80% of the time, if someone does click the link, it takes place in a minute or less. So 60 seconds for a criminal to access your system. Conversely, only 3% of those incidents are discovered within minutes. So while there is an extremely high success rate for a criminal to get in your system quickly, in fact, most of the time, those breaches are not discovered until months after the fact. And to make it even worse, as you've surely seen in the news, Most of the time, those breaches aren't even discovered by the company who got breached. It's usually some sort of third-party blogger, a security analyst, or perhaps someone like me who figures out that, whoops, all of your data is accessible on the internet for free, and I can steal it and use it. Maybe you should fix this. And, oh, wait a minute, this hack happened months ago. That's exactly what happened to Target, Sony, and others. Most of the big attacks we see, again, very quick to happen. They get access to your system. They start living in there, and it's going to take you, statistically, months to find out that they're even in there. Now, to get more specific on why this is a particular issue of law firms, you'll remember a couple slides ago that I said professional services maybe not the most attacked industry now. Here are some things to consider though. Number one, like I said earlier, and again, I don't mean to be disparaging, but traditionally it's been my experience working in law firms and working with other lawyers, we're not the most technically advanced group of people on the planet. There's a reason we went to law school instead of engineering or computer science, right? So number one, there can often be a gap between knowledge and understanding, right? Especially for those partners that are at a high level that have maybe been with a firm for a number of years and they're already set in their ways. Trying to educate those people on the evolving nature of technology and cybersecurity, which changes rapidly, can be a bit of a struggle. So you may have a bit of a personnel issue, like I said on that previous slide, worrying about social engineering attacks or other internal attack vectors just based on a pure lack of awareness around technology and threats. The other big thing that's affecting law firms is criminals are starting to realize what I just said on top of the value of the information you hold, right? So we saw that healthcare is a huge industry that's constantly under attack because there's so much data in their lake. I would argue that law firms have even more valuable information in their systems. Think about the type of typical activities that big law firms or smaller firms are engaged in. You may have criminal histories, personal detail that can be used in blackmail. Same goes with court documents or other sensitive data. You may have financial data or mergers and acquisition plans that can be used and monetized around the globe, right? People are trading stocks in advance of that information. You may have trade secrets and other intellectual property. Fundamentally, guys, what you need to understand is as a law firm or as a lawyer, the information you hold is extremely valuable. That's why you're constantly subject to a variety of rules, right? Attorney-client privilege and all of these other things. That means that you are an attack vector. You have a vault of information on your systems in the same way that a bank has a vault of money. And criminals are only going to start attacking you guys more and more and more to try and get at that information. Because guess what? Hacking a Facebook or a Google, yeah, I can get a lot of personal detail about someone and maybe I can get their ad profile, but it's a lot more valuable to get trade secrets and corporate information that I can actually trade on, monetize, and use. So something to consider there, right? What's the value of identity theft versus selling intellectual property online, trading on mergers and acquisitions plans in advance of those mergers, that kind of stuff. So again, there you can see some other things like topics described. Industrial espionage, maybe you're a vector of attack because you represent a client and people are attacking through you to get to the client, right? You're emailing your client, you maybe have access to their systems by virtue of a password. If your networks are compromised, they can use you as a stepping stone to their ultimate goal. Now, another thing to consider there, Bitcoin mining seems to be kind of falling by the wayside as the price of these cryptocurrencies fluctuates. 2018 was a hot year for Bitcoin. I don't really trade in it, and I think the price is going down. But one of the issues we've seen in the cybersecurity space is that hackers will get onto your networks, get onto your devices, and they will install bots that will use your device to actually mine Bitcoins. And the technology is a bit over my head, but ultimately, the criminals will take advantage of your lax security and use you as their base of operations for criminal activity. And I've seen this actually play out. I went to a meeting of the Colorado Cloud Security Alliance a couple weeks ago, and a gentleman had tested this idea. He set up a server, technically set up 2 servers, and threw some files up there. He made the account name admin, and he made the password with a capital P a 0 instead of an O, and an exclamation point, right? Maybe not the most secure password, but it's pretty good. That server was hacked within 7 hours. Within 9 hours, this gentleman was locked out of his own server by this hacker. And you know what that hacker did? Started making fake dating accounts on this gentleman's server so that he could engage in identity theft and make it look like this guy was doing it. So again, something to consider there. They may not even be trying to steal your information. They may just be using your network or your server, your IP address, to tie the criminal activity to you. So 6 months later, you get a call from the FBI. I have no idea what this is, but they've been investigating for months, and now they have to physically take your devices, your laptops, computers, servers, etc. The business continuity issues there are unimaginable, especially for a law firm. So something to consider there. Again, of course, ransomware as well. Always, there's going to be value in information, and if someone can simply hold you ransom for it, why not, right? So that's something to consider on why law firms are increasingly a target of cybersecurity threats. Now, the graphic we see on the right here, that is a graphic I took from Wikimedia Commons, and that is the location of clients implicated in the 2015 hack of the Panama Papers. So for those of you that remember it, or maybe you don't, quick refresher, a couple years ago, there was a law firm down in the country of Panama. This law firm was supposedly doing a lot of tax beneficial activities, not necessarily shady, but maybe a little bit evasive, dodgy, questionable, I'll say, kind of in that gray spectrum area, right? So this was a law firm that was hacked, and look at all of their clients around the globe that were impacted. I remember when this story came out, and so you can imagine, again, just because you're a law firm and maybe you're not a big highfalutin tech company or you're not a major hospital network, don't think that you're safe. Your clients have extremely valuable information that they've entrusted to you, and as a result, somebody is going to find a way to steal it from you. And they're either going to steal it directly from you or take advantage of your lax security and your inadvertent attention and use it to directly access your clients. So something to consider there. You are essentially, in a way, a bit of a security guard for your clients' information now. So again, much of like I just said, the real firms are an increasing target of cybersecurity attacks is frankly because they're easy. And we can see here some other topics. There's a variety of other things that are protecting other industries in this space. So healthcare networks, like I said, yes, they are a common attack network. Yeah, do they maybe understand technology very well? I don't know. They're doctors and nurses, not to say that they're unqualified, but healthcare as an industry has been regulated by a cybersecurity and privacy law for 15 plus years. So they kind of do know what they're doing, and most of them do a pretty good job. Same goes with a lot of other industries, guys. Financial companies are subject to a variety of cybersecurity and privacy regulations littered throughout US statutes. Public companies are subject to accounting and other cybersecurity rules, defense contractors, retail companies, etc. So you can see there a variety of industries have their own industry-specific laws that regulate what I'll call data governance. Law and the practice of attorneys does not. And so as a result, while other companies have been figuring this out since the late 90s, most law firms that I've worked at or consulted with have no idea about any of this stuff, and they're just waking up to this scary dream that other people have been dealing with for a number of years. So that's another reason why law firms are easy. It's not just the value of the information you hold, it's also the fact that you may be 2 steps behind everybody else who has valuable information. And all things considered, right, criminals, if I can take an easy target, why not? So where do we start? From a practical level, you need to start focusing on what information you have and really think about it in a twofold manner. Number one, literally, what data do you have? Is it IP trade secrets? Is it personal data, health data, et cetera, et cetera, et cetera? But then also, where does that data reside in your business? Does it live on information technology assets? Are they old school paper files? Are they administrative systems? And then as a layer on top of that, who actually manages those things, right? Are the paper files within your office in a lockbox, or are they managed by a third party? Are the IT assets on-prem, or are they on the cloud? Something to consider there. You need to figure out your ecosystem of data. Where do these things reside? What are the current levels of protection? From there, you can start to assess your current gaps in compliance. So you can assess your network and the controls you have on it and compare it to the actual legal benchmarks that we're going to get into here in a second as we discuss rules, right? Now, like I said, in the practice of law, there is not a real industry-specific governing framework. There are rules that are outlined by the Model Rules of Professional Conduct. Every state in the United States has a data breach notification law. Oftentimes, it's been my experience that states will have customer records provisions that also deal with the control and maintenance of data. And then for those of you that have been paying attention to the news, California recently released a privacy-specific law that deals with the control, collection, and storage of personal data. So another layer of complexity that we'll get into. But as you start to understand your gaps between your baseline security requirements and what you have in place, you can develop a action plan, right? And you can start to prioritize things based on what you just discovered. What are your most high valuable, high priority risks? Those are obviously going to be more important and further up on the action plan list, as opposed to perhaps your low value data that already exists in a secure area. From there, you can start to pick and choose people, process, and technology. Start to figure out what you can use to automate these processes to hopefully minimize some of those attack vectors I talked about. So for example, we'll talk here in a sec, but if you have a good process in place, or perhaps your systems are technologically controlled, as an example, you can very easily prevent internal employee hacking through some sort of data loss prevention technology. And I've seen a variety of them out there on the market. Some are really great. But as a very basic example, guys, are you worried about your employee stealing client data and taking it to a new law firm? Well, then you simply make sure that your IT department mandates all employee technology assets are not allowed to use removable media. You can't use a USB stick on your laptop. That way nobody can steal anything. You can play with those and talk to your IT department and find what suits your business. But again, there's a lot of process options or technology options that can hopefully lower that impact that people, humans, inject into your risk all the time. And then, like I said there, you can always look outside for help. There's a variety or no shortage of partners that are happy to jump into that space and tell you how they can solve your problems. Microsoft, variety of risk management options, and of course, consultants like IT governance. We're always here to help you. But let's talk now on the rules. Oh, and give me 1 second, guys. It looks like I had a question come in. Apologies. So let me see if this is applicable to us. Okay. So, let's see. I got a question. Can you elaborate on why the single individual breach in your example would require notification to all 50 state attorney generals? Okay, so great question. And for those of you that, to just refresh us, so I kind of threw out a hypothetical that if you had a breach, you'd have to be required to notify a bunch of state attorney generals. That would be a really fact-specific sort of a discussion based on the details of the breach. Technically, you would only be required to notify the state attorney generals of, affected individuals or citizens from those states. So for example, and don't hold me to this exactly, but as a rough example, let's say you had a data breach, but none of your customers or clients were from California, well then you wouldn't need to notify the California Attorney General. Unfortunately though, with the increasingly broad nature of business that is able to be done over the internet, that's where we run into that issue, right? And so if you have clients scattered across the country, now you're going to have a very complex compliance situation, because how are you going to manage all 50 different requirements? Whereas if you're more of a small practice and you're pretty much localized in one state or one area, you may be able to better outline your notification response requirements. Let's say you're a law firm based in Kansas City, Missouri. You may only need to notify clients affected, so Kansas, Missouri, maybe Iowa, Nebraska, Arkansas, Oklahoma, those types of places, right? So that's a great question. Yes, you're not obligated to notify all attorney generals. Typically, you're only obligated to notify the state attorney general from the state where consumers are affected. To go a layer deeper, there are sometimes requirements where you don't need to notify the attorney general if the number of affected individuals is under some certain number. But for most large companies operating on the internet or selling on the internet, you're going to have a very tricky situation in trying to decide where exactly your customers and clients are from, unless, again, you're a small practice that's very localized. So that's a great question, though. And again, hopefully maybe in the next year or two, we'll see some movement on a federal law that really clarifies that in more detail for us, just to who we need to report to and when. But with that, let's get back into the rules here. And again, these rules are really looking specifically at the model rules of professional conduct. So as it relates to that last question, I would advise you, every state has a data breach notification law at this point. So chances are wherever you're operating, you're subject to one or more actual legal obligations under statute to report data breaches. Like I said, that may involve a variety of other issues like document management or cybersecurity practices. Here in Colorado, we actually had a law come out last fall around cybersecurity, and it basically says you have to maintain reasonable cybersecurity if you're dealing with the personal data of Colorado residents. Here, though, I'm specifically talking about the model rules of professional conduct that apply to the practice of attorneys. So there are several rules that have been implicated by cybersecurity or technology, and for more information, I would point you specifically to the American Bar Association's formal opinion number 477. It was released in 2017, and a lot of that formal opinion has interpreted these model rules to apply to technology. So you'll see there, Model Rule 1.1, that deals with competent representation, right? Basically being a competent attorney. In order to do so, you have to understand the benefits and risks associated with relevant technology, right? Model Rule 1.4 deals with reasonable steps to communicate with clients, either during the course of your engagement or especially if there's some sort of issue or incident related to their case or proceedings, right? So just that idea that you have to be in touch with your clients constantly, et cetera, et cetera. Model Rule 1.6 deals with the confidentiality of the client-lawyer relationship. So again, obviously a huge one, and the rule actually says a lawyer shall not reveal information relating to the representation of a client unless certain circumstances arise. Surely you can see how that may be implicated by technology, but we'll get into that here more in a second on the application section. Again, just kind of flying through to pinpoint where I'm coming at with some of these. So again, on the first slide here, you have to be a competent attorney. That includes understanding the benefits and risks associated with relevant technology to provide good representation. You have to take reasonable steps to communicate with your clients, and you have to secure those communications. To go further, Model Rule 5.1 says that a partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority shall take reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. All right, so high level, it's basically, and Model Rule 5.3 is similar, by requiring lawyers who are responsible for managing and supervising non-lawyer assistants to take reasonable steps assuring that those assistants are acting in a way that's compatible with the ethical duties of the lawyer. Model Rules 5.1 and 5.3 are basically saying that the higher level executive attorneys practicing in your office need to ensure that non-lawyers and more lower level junior associates who maybe just don't have the experience are acting in a way that conforms to their ethical duties and conforms to the rules of professional conduct. So essentially, you are not able to stand up and say, well, that was a rogue employee who went outside of what we told them to do. No, no, no. You're supposed to implement a system to make sure people follow those rules. So you've got to be taking steps to ensure that all employees understand their duties as it applies to cybersecurity, and that they understand their duties under these model rules here. Now, formal opinion 483 goes a bit further with regard to breaches, and it actually said that lawyers need to act reasonably and promptly to stop a breach and mitigate damage, and that they should proactively develop an incident response plan. So the American Bar Association got a little more pointed on us with that, and that was nice of them. But again, like I said, formal opinion 477 from 2017 actually gives us a lot of detail related to these rules. And so we'll see that here in the application section. And specifically what I'm going to do here is try to point out how an information security management system, or an ISMS, will help actually manage and govern your information security risks. So everything we talked about at the start of this call, you need to start to bring some framework, governance structure in order to help manage these things at a real business operational level. It's no longer about avoiding legal issues point by point. You have to bring structure and guidance to this in order to effectively manage this at a business level. So to that end, Model Rule 1.1, you can see some bullets on the slide for ideas of how you'd protect against this, but comment 8 from Formal Opinion 477 actually states that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, and engage in continuing study and education to comply with all continuing legal education requirements, right? So for those of us that are attorneys, we know about those annoying CLE requirements every year. This rule is now being interpreted that it's not just enough to understand the evolution of the law, you actually also have to understand the evolution of legal practice. And that involves understanding that technology that facilitates that legal practice and the risks involved. So you may start to look at training or awareness programs within your organization, especially if you're a small law firm that doesn't do that type of thing, start to think about mandating it. Educate your people to prevent you from risk and start to demonstrate that you're meeting your obligations under Model Rule 1.1 because you're constantly, at least annually, educating people on technology and risks and how to protect them from those risks, right? Now, Model Rule 1.4 was explained in Formal Opinion 477 to say that when a lawyer reasonably believes that highly sensitive, confidential client information is being transmitted, he or she should consider extra measures to protect that transmission if they're warranted, and the lawyer should inform the client about the risks involved. The lawyer and client can then decide if another mode of communication is warranted. What does that mean? Again, the value of your information is incredibly high. You may be under an increasing legal obligation, if not already outlined by what I just said here in Model Rule 1.4, to encrypt your information in transit. So I would ask you to think about yourself critically. Are you encrypting all of your emails as they're sent to clients? Are client emails encrypted when they're sent to you? Do you have an encrypted communication channel to protect those communications? If not, you may be at risk here, and we'll talk about that more in a second as it applies to 1.6. On a second option, you need to consider disaster recovery plans and business continuity management, so that if your systems are taken down, what are you going to do to maintain that protected level of communication, right? So if your email server goes out, what are you going to do as backup? Maybe you rely on physical delivery of papers, kind of go back to that old school model, at least that's very secure. Unencrypted email is probably increasingly going to not be good enough here. Now, the reason I say that is precisely because of 1.6, right? A lawyer shall not reveal information relating to the representation of a client. Subpart C to Rule 1.6 goes on to state that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. For those of you that have pored over those 50 state data breach notification laws or Europe's GDPR, you'll recognize that language. Inadvertent or unauthorized disclosure of information, that's a data breach. So a lawyer has to take reasonable efforts to prevent data breaches. What are you doing in that regard? Is your data encrypted at rest? Have you engaged in penetration tests of your network or other vulnerability scans? Or even at a more higher level, what's your network architecture like? How are you actually preventing a data breach? An amended comment to this rule went on to explain that a lawyer needs to act competently to safeguard information relating to the representation of a client against unauthorized access. The unauthorized access does not constitute a violation if the lawyer takes reasonable efforts to prevent it. In order to develop a reasonable effort standard, Comment 18 to Model Rule 1.6c includes several factors. Some things, again, you'll maybe see replicated in US state laws or perhaps Europe's GDPR. So some things to consider when you're trying to decide, hey, is my security actually reasonable? What's the sensitivity of the information at issue? What's the likelihood of disclosure if additional safeguards aren't implemented? What's the cost of employing those additional safeguards and the difficulty of implementing them, trying to balance that risk reward a little bit? And then finally, what's the extent to which the safeguards adversely affect the lawyer's ability to represent the client? So as a result, what we're left with is a fact-specific approach to business security obligations that require a process to assess risk, identify and implement appropriate security measures responsive to those risks, and verify that they're effectively implemented, ensuring that they are continually updated in response to new developments. Keep that language in your mind. Now, Model Rule 5.1, like I talked about, 5.1 and 5.3 are basically making sure that your employees are acting in a way that's compliant with Model Rules of Professional Conduct and Ethical Duties. What do you need to do there? You need to start building a business operation structure. All right, so for those of you that have joined us today from small law firms, you are, by virtue of the data you have, you are too big to be small anymore. So you need to start thinking about business operations, the type of stuff that we precisely went to law school to avoid, right? I didn't go get an MBA because I didn't want to do this stuff. Well, now you need to start thinking about things like policy management, business procedures and processes, developing an information security manual that outlines the requirements that apply to all employees and their use of company assets. And then maybe at a higher level, looking at things like a risk governance framework that we're going to talk about here in a second. Also, constantly examining your service level agreements with partners. Again, like I said, if you've offloaded a lot of your data to the cloud, how are you ensuring that those cloud service providers actually meet your requirements? To go further then on Formal Opinion 483 that talked about developing an incident response plan, like I said, you've got all of these different state attorney general requirements. If you're not thinking about this ahead of time, I will tell you from experience, it is impossible to do in the heat of the moment. When somebody calls you and tells you that there is a critical data breach and that you are going to have to start drafting notices to customers, drafting notice to regulators, drafting a PR marketing message to put out in the news, and all of this needs to happen within a certain time frame that's technically different across 50 different states, again, maybe depending on where you operate, gets confusing, gets messy. Obviously, people are stressed in that moment. People are freaking out. So if you don't have an incident response plan ahead of time, there's no way you're going to even remotely have an accurate or appropriate incident response plan after the fact when an issue does arise. So something to consider there. What does this actually mean? You need to start looking at risk management frameworks. Again, this is a topic that's been around in industry for a long time, but I don't know that law firms are typically or totally familiar with it. So you need to start looking at governance, risk and compliance, enterprise risk management, variety of acronyms out there, but essentially you're looking for a framework that provides consistent procedural approaches, so it doesn't matter what employee is doing it, it's consistent every time, bringing that level of consistency to risk assessment and risk treatment to deliver consistent, comparable results. You are effectively assessing risks and treating them the same way over and over and over. So you're looking at your hardware, your software, your data. You then go through that risk assessment like I talked about. What information do you have? What risks does it pose? What are your existing legal obligations? And you start to do a bit of gap analysis to bridge those two worlds. Now, a statement of applicability, that's something specific to ISO, that's actually going to outline and bring structure to some of this, right? So it's not just a theoretical idea that floats around in your mind. Maybe you actually have a corporate risk register where you outline what your risks are, where you keep track of your legal requirements, your contractual requirements, and then you can compare those to what you're actually doing so you can give that sense of corporate governance to risk. This is not just me screaming that there's a fire on Monday morning. We've looked at this risk, we've assessed it, we've measured it, we know what our treatment plan is, we know we're working on it. Gives a level of assurance to regulators that you know what the hell you're doing. Gives a level of assurance to your business partners that you know what the hell you're doing. And then further, like I said, by bringing that procedural or process type of approach, it ensures that regardless of who's doing it at your organization, paralegals, secretaries, juniors, associates, of counsel, partners, whoever it may be, the guy that's been there for 50 years and doesn't like to use computers, everybody is doing it the same way to protect risk in the same way and not inject some new risk in an inadvertent manner. So what you can look at, variety of risk management frameworks there that are presented on the right. These can be adopted as a high-level governance model, or you can pick and choose from their security controls. Perhaps you just want to start to tack on things, but again, something to consider there. So you've got NIST here in the United States. They've got a cybersecurity framework and are working on a privacy framework before it was derailed a little bit by the government shutdown there. We've also got ISO 27001 that relates to information security, COVID. There's other various controls required in industry, but I would tell you to focus on those high-level risk management frameworks. Because again, it's not just going to provide you with technical security controls, it's going to help you build that into an overall management system to know and understand why are we applying these controls, what are they doing, what's their actual quantifiable impact on the risk that we have, is this moving our law firm in the right direction? So now what? I'll try to finish this quickly so we have a couple minutes for questions. What does this mean? You need to start focusing on these topics, right? Disaster control is no longer just IT context. It's across the organization, and you need to start protecting yourself to limit liability and control fallout. So these are topics that if you've got a pen and paper, write it down. You need to think about them if you haven't. What are you doing to control access to systems and devices? You can see things there like user account management, privileged account, password management, all topics under access control. What are you doing to encrypt or otherwise protect your sensitive information, both at rest and in transit? What about your cloud access, right? If you're dealing with cloud service providers, how are they protecting their information? What are your obligations, either legally or under contract? Some of those companies are really great at explaining it, like Microsoft. Others, like Amazon and Google, are just going to tell you to read the contract and figure it out. And if you don't like it, get out of line. So there's some difference in choosing cloud service providers based on that level of service they meet you with. And then, of course, like I talked about, always incident response, thinking about it before it even happens. What are you going to do if there is a disaster? What are you going to do if there's a business continuity issue? And those are different. Disaster, there's a flood, there's a fire, there's a gunman, the system goes down. How are we going to bring the system back up? Business continuity is there's an issue, and I don't really care what it is, but how am I going to make sure that the business continues running, right? So if everything on the above side of the screen, right, your hardware and software goes out just because the power is down, hopefully somebody's working on the power being brought back online. At the same time, though, you still got to call clients. You still got to communicate with them. You still got to protect their information. Just because there's a disaster doesn't mean that you're absolved of your legal liability here. Some other things to consider: boundary defense, interior defense, and like I said, overall risk management. Boundary defense, that's going to be protecting your perimeter, spam filters, phishing filters. On these topics, there's no shortage of technology that you can and should be implementing to protect yourself. But you also have to think about interior defense as well, right? Like I talked about DLP solutions that make sure your employees don't steal data. That's that exfiltration or data loss prevention technology. Obviously, antivirus and anti-malware software is going to be hugely important, but increasingly there's a lot of cool technology in this space to help us. Intrusion detection systems, monitoring and other logs. If you engage in a BYOD practice where you can bring your own device, employees are allowed to use their personal computers or personal cell phones at work, oh my God, the risk that you have just injected into your business by letting everyone bring their own computer onto your system. I mean, I can tell you right now, how often do you think I update my iPhone? Do you think it's controlled as tightly as my work computer? No, no, no. So you have to have policies and practices in place, because that's just a huge, huge risk you're injecting into your business for the sake of convenience. But it can be managed and balanced. Again, the important thing, you got to have that overall approach. If you decide to adopt some of these technologies, if you decide to take a chance on some of these risks, that's fine, but you need to understand what you're doing. It's not just enough to say yes or no in the moment. You need to bring some sort of governance to this overall corporate structure in order to really manage this risk. Because risk management and increasingly legal practice is not a black and white yes or no, it's illegal or it's not. It's about taking those educated guesses in order to manage risk based on priorities, urgencies, importance, and then also resource availability and the actual risk involved, right? We don't apply the same prophylactic to every risk, because that's just not suitable for what we're doing. So, like I said at the start of the call, of course, IT governance is here to help. We have a variety of training options on GDPR, ISO, and a broadening subset of US specific topics. So whether you're looking to educate yourself or perhaps just roll out annual training like I talked about to your own company, variety of tools and options there that we can help you with. For more information, feel free to reach out to us and we can discuss. Also, a variety of consultancy services like I talked about as well. So if you are struggling with any of this effort, you don't know how to conduct a gap analysis, you want somebody to just do it for you, we can help you with that as well. So again, feel free to reach out, contact information to be sent after this call. variety of things we can do to help you assess your current level of risk exposure, understand it, protect it, and then bring that sort of high-level governance structure to your evolving practice so that you're taking these things into account over time and effectively reducing your liability. Borrow my tinfoil hat for a second, and I'll say within 5 years, you're probably, by doing some of this stuff, you're probably going to reduce your insurance premiums. So inside scoop there, I know from some friends at the Hartford that that's the route they're going. If we start having to sell people cybersecurity insurance or legal malpractice insurance, you're going to get a high premium unless you can show that you're doing active risk management, because otherwise we just can't trust you. There's so many threat vectors, so many opportunities to be exploited that we have to understand and really know that people are doing this in a coordinated, cohesive, and consistent manner. One of the benefits, which I failed to mention, of ISO 27001 is that you can actually get certified. So Ohio recently released a law last fall that said specifically, if you are subject to a data breach and you are subject to a tort-based lawsuit as a result of that data breach, you can effectively defend liability by pulling out your ISO certificate. You're right. So we talked earlier about reasonable efforts to maintain cybersecurity. What is better than pulling out an industry accepted certificate and saying, we're subject to external audits, we've had this certificate, we are industry certified, go away, you know, lawsuit over. So something to consider there as we work on this evolving body of law in the United States. If you want to really reduce your liability, reduce your obligations when it comes to third-party management, and reduce your insurance premiums, go after the accredited certification. Don't waste time with everything else, just achieve certification, right? So again, ITG has a variety of tools to help you there, documentation, toolkits, training, et cetera, et cetera. With that, I'd like to open it up for questions because I know we're at the top of the hour and essentially we are at the end of our content. So if there are questions, feel free to type them into the box here. I've got it live and open. If you don't have questions, feel free to log off. I appreciate you joining us today. And I would ask you to, again, tune in for upcoming webinars on this and other topics. In the next months, we'll be doing a more in-depth review of California's Consumer Privacy Act and what that means for industry in terms of its requirements, its material and territorial jurisdiction, et cetera. So a lot of good, interesting stuff coming on the topic of data privacy, data protection, and cybersecurity here in the next couple of months. But of course, you're welcome to reach out to us at any time for assistance or information. And again, I'll reiterate, like I said at the start of the call, for those of you that have joined us today, you're eligible for a 15% off discount on any ISO products purchased between now and March 31st. So if you're thinking about ISO certification, or perhaps you already have it and you're working on your annual ongoing audits, something to consider there as well. There don't appear to be any questions that have come in as of this time, but I'll hang around for a bit more. Again, thank you for joining. My name is Preston Bucati. This is IT Governance USA, and I ask that you join us again next time. Okay. Okay, there does not appear to be any questions. What I will say, I'll just kind of elaborate previous questions submitted, right? Why would a single individual breach be required to notify all 50 state attorney generals? It's been my experience that most state data breach notification laws are written in such a way that a notification is required if a certain number of consumers are affected, right? So a certain number of affected consumers. Typically, consumer is defined elsewhere in state statute to essentially be a state resident, right? A California resident, a Colorado resident. So ultimately what happens is if you have a data breach, you need to understand whose data was breached. That will inform you of which attorney generals to notify. Now, if you are, I shouldn't say a small practice, but let's say you have a small data ecosystem, you know, it's relatively limited in size and breadth. You really do understand where your clients are located. That could maybe be a very easy sort of analysis to go through, right? Hey, we lost access to our data. We know where these people are located, so we know who to call. However, if you're a large business and you've got a lot of information, are you going to want to spend the real time and money to sit there and sort through which state attorney generals you're going to notify, right? So let's say you have clients scattered across the US and you think maybe a pot shot only 50% of your clients are affected, or excuse me, 50% of states are affected. You know, do you want to spend 4 hours sitting through and peeling those apart, or do you just want to start to develop an overall incident response or notification process? That's really the bigger thing that it comes down to. And so again, you know, we're in a tricky situation now as a country because we've got a variety of state interpretations. Those are increasingly being layered, and presumably, at least based on what we hear in the news, you know, industry titans, Tim Cook at Apple, you know, certainly not Mark Zuckerberg or Larry Page, but Apple, Microsoft, and Cisco are really trying to push for a federal privacy law. You know, Google and Facebook profit immensely on data, personal data that they've taken without consent. So they're obviously antithetical to any privacy law. But ultimately, in the next 2 years or so, you know, depending, you know, big asterisks next to the federal government there, but presumably we try to see some sort of federal law that preempts these state laws and brings a level of structure to this that's a little bit more easy to deal with, because yeah, ultimately right now we've got 50 different interpretations. They're not wildly different, but they are slightly different, and that's ultimately the issue, right? If you're based in Miami and you know you only need to deal with Florida's law because you only have Florida clients, well, hey, that's great. But if you are based further north in Florida and perhaps you've got clients in Alabama, Mississippi, Georgia, Tennessee, how much time and energy are you going to want to spend developing separate incident response processes based on where your clients are, so that when you have a breach, you can go through that effort? Or do you just want to have one master notification that meets obligations everywhere and you just fire it out? Again, that's sort of that difference between legal and risk management, right? So legally, would you be required to notify all 50 state attorney generals? Maybe not, but the risk management would say, you know, it's just going to be faster, easier, more expedient to prepare one giant notification that goes everywhere and covers us in every place, as opposed to dealing with it in each individual state. Again, though, it sort of depends on the data you have and your risk exposure and all those sorts of details. And that's why some of these concepts of ISO, NIST, and others are great to start to adopt, because they'll help you manage that in a more structured way, less of a ad hoc decision in the moment, and more of a real corporate governance sort of an idea. Well, with that, we're now closing at a couple minutes over the top of the hour, so I apologize for going over, but as I'm sure you can tell, I get awfully excited by this stuff. So if you guys have more questions, feel free to reach out directly, or you can find me on LinkedIn and other social media outlets. Happy to chat your ear off about all of these kinds of things. If there are no more questions, I'm going to sign off. So again, thank you those of you that joined. Thank you for the questions. And again, keep your eyes peeled for upcoming webinars on this topic. We're trying to get out ahead of the California Consumer Privacy Act, so there should be a webinar here on that in the coming weeks, where we start to peel apart how that law evolved, what companies it applies to, what the actual requirements are, what the financial penalties are, et cetera, et cetera. California law being perhaps a guiding force in what we may see in other states over the course of the next year or two, or perhaps, like I said, any sort of potential federal law that comes out on this topic. So again, thanks all for joining. We plan to send out handouts and copies of this information after the call, so you can always reach out for more, or just simply contact us through any of the channels mentioned here. Again, Preston Bucati signing off. Thanks all for joining.